Good morning to our participants and welcome to this seventh session of the Environmental Law Teachers Online Training Program. This training program is developed by the Legal Education Board in partnership with the Asian Development Bank, International Union for Conservation of Nature Academy of Environmental Law, and the UN Environment Program. I am Gabriel Matola from the Legal Education Board and I will be your host today. The topic for today's session is role of courts in addressing environmental protection in the Philippines. Before we get started, let us have a brief recap of our last session. We have discussed the topic on pedagogical enrichment on environmental law with our resource speaker, Dr. Georgina Lloyd. The lecture focused on experiential learning, methods of enhancing student engagements through online and in-person strategies. We also had a dialogue with Attorney Rose Liza Isma Osorio on environmental law moot court competition and with Attorney Ernesto Neri on student internship program with NGOs and student-led seminars. Lastly, Mr. Kenny Bayudan, National President of ALSP, shared his experiences as a law student on how environmental law subject is currently taught. Now, to begin our session, I'd like to go over our house rules. Participants who join the event consent to the recording of their participation. The event will be recorded entirely. Mute your microphone while waiting for others to join in and when not speaking during the session. You may use the chat option if you have questions or comments, and click the reaction option to interact with our speakers and guests. You may turn off your video camera to lessen the amount of bandwidth for everyone in the meeting, but we also encourage everyone to show their lovely faces to our resource speakers. The links to the registration form as well as the evaluation form will be sent in the chat box. Kindly check our chat box and fill out the registration form to confirm your attendance. The evaluation form will also be sent to your email and you may fill it out after today's session as part of your attendance. We remind everyone that the 11th session on December 8, 2021 is a non-mandatory session and we now require the attendance to at least 8 of the 11 sessions. Okay. Also, for today's session, we will also be having an interactive quiz using the Kahoot app. Everyone who wishes to join are encouraged to use two devices to comfortably navigate through the website. But those who have limitations, you may also use your computer by opening another web browser. To prepare, please open a web browser and open the Kahoot by clicking the link sent to your chat box. The game pin will be announced and flashed to the Zoom screen later. After joining, please name yourselves in the following format. Okay. The quiz is designed by Professor Galahad, and for the benefit of time, we have only allotted 10 seconds for each question. So good luck. The point system is based on the speed of your answering, and the winners for the quiz will receive a complimentary gift vouchers from Fully Booked. So I hope everyone will participate in our quiz later on. All right. Let us now begin the session with a lecture from our invited resource speaker. Our first research speaker, Attorney Galahad Pebenito, earned his Juris Doctor degree from the Ateneo Law School in 1994. In 2003, he acquired his Master of Laws in Energy and Environment with distinctions from Tulane Law School in the United States. As a graduate environmental law student, he specialized in hazardous and toxic waste regulation, marine pollution, and pollution control. Professor Galahad teaches environmental law, conflict of laws, and land titles and deeds at the FEU Institute of Law, Lyceum College of Law, and MLQU School of Law. He is a mandatory continuing legal education lecturer for the Integrated Bar of the Philippines on environmental law, international law, and legal writing. He advises and represents environmental groups and was a consultant on environmental matters for the Archdiocese of Manila. In addition to being licensed in the Philippines, Attorney Pebenito is also a member of the State Bar of California. He is the author of Environmental Law, Pollution Control, ECC Basics, and Conflicts of Law. Ladies and gentlemen, let us all welcome Professor Galahad Pebenito.
Thank you, Gab. Good morning to everybody. It's a nice day today. It's a sunny day, and it's just good for everybody else to continue studying environmental law. So this morning, I'm going to discuss with you the role of courts in environmental regulation. Let me just share with you my presentation. And let me maximize. So this is role of courts in environmental regulation. Before we even discuss the role of courts in environmental regulation, um, I'd like to discuss first the role of government in environmental protection. So let me cite to you two instances where the government has performed their duties under the law. So last year, the Department of Environment and Natural Resources came up with the beach nourishment project in the Dolomite Beach. And they said that no environmental impact study is needed for the putting up of the beach, despite the fact that all reclamation projects in the city of Manila and Metro Manila, by the way, have been classified as environmentally critical projects in an environmentally critical area. So according to the DNR, this enhances environmental quality. So no need for an environmental impact study. The next instance that I'd like to show to you is uh, Ombudsman Martires, wherein in 2018, he recalled the suspension order of several mayors and local executives charged with non-compliance under the Solid Waste Act. He said that small municipalities, fifth and sixth class municipalities should be exempted or should not be subjected to the requirement of sanitary landfills under the Solid Waste Act because they are just economically infeasible because they do not have the funds to put up a sanitary landfill. So that's the background of our discussion with respect to government regulation. Now let's go to some provisions of law specifying the role of government. First, we start off with the Constitution. It states that people have the right to a balanced and healthful ecology, and that the state shall protect the same. Notice the use of the word shall. It is of a mandatory and strict nature. That is section 16. Also, under the local government code, okay, local government code section 16 states that uh, LGUs must enhance the right of the people to a balanced ecology. Again, the wording is shall. So LGUs are bound by the law, bound by the strict provisions of the law. Again, in section 2 of PD 1151, it states there that it is the responsibility of the government, in no uncertain terms, the law used this phrase, to use all practicable means to see to it that environmental values are factored in the decision making of government. So this is section 2 of PD 1151. Okay? And we also look at the mandate of the DENR. And the mandate is simply purely conservation, management, development, and proper use of the country's environment and natural resources. Looking at all these laws, we can see that the role of government is to execute and enforce the laws. There are laws promulgated by Congress such that the executive branch has no other choice except to enforce these laws, and not only enforce these laws, to faithfully comply with the requirement of the laws in such a way that they carry into effect the legislative intent of Congress as well as the provisions of the Constitution. That is, to faithfully comply with the laws. Okay? Also, the role of government. Government has the role function of protecting the environment, nature, and human rights. In the Dutch shell case, which was shown to you in the previous video, the court there said that government has the duty of care to protect the environment, nature, and human rights. So we have all seen the role of government. Okay. One case in the United States states that the government is not simply an spectator. It is not an umpire in a basketball or a baseball game. Government must itself take the initiative. It must be proactive. If there is no opposition, government must itself consider environmental values. It must not ride on with economic development or any other consideration. It must take upon itself the duty of protecting the environment. Okay? The government is an active participant. This is pursuant to the case of Calvert Cliffs Coordinating Committee versus AEC. Now, so having learned the role of government, where does the court come in? Let us see how courts will exercise their role in view of the fact that government has this role, right? What is the role of courts? So, role of courts, again, in the case of Calvert Cliffs Coordinating Committee, the duty of courts is simply to see to it that important legislative purposes heralded in the halls of Congress are not lost or misdirected in the vast hallways of the federal bureaucracy, because government has this tendency of just ignoring environment considerations put in by Congress when they implement the law for whatever reason they may have. It can be economic, it can be technical, but there's there's this tendency by government to ignore certain values enunciated in Congress. So courts must ensure that these are followed, right? What else is the role of courts? It is to faithfully comply with the rules of environmental procedure. And I will tell you later on some problematic provisions of the rules of environmental procedure. Also, courts must exercise openness and adopt new innovations and approaches in the field of environmental law interpretation and enforcement. Because if courts are going to apply traditional approaches to interpretation, traditional approaches in the field of law, we are bound for disaster because they are just not fit for environmental law. So there are now new innovations, natural resource damages, SLAP, citizen suits, which are not does not follow traditional approaches in law. So these are the role of the courts. Okay, role of courts. Let's say um, one case in the United States, TVA versus Hill, states that once Congress, upon exercising its power, has decided the order of priorities in a given area, let us say Congress decides that number one should be environmental protection, number two is economic development. The executive branch cannot exchange the two. The executive branch cannot put in economic development as number one priority and then make environmental protection as number two priority. That is the time when courts can come in. It says here that it is for the executive to administer the laws and for the courts to enforce them when enforcement is sought. Okay, so we should look at a directive from Congress and look at the actions of the executive branch. And if the executive branch does not comply with the mandate of Congress, courts can come in through people enforcement. So this is the role of courts. Okay, now let's go back now as an example. Let's see if there is a problem by considering when you consider economic and technological infeasibility. And this one, the Supreme Court of the United States is pretty clear on this because in this case, one electric utility company also alleged that it cannot comply with a state implementation plan on the ground of economic and technological infeasibility. Union Electric was somehow saying that it is a violation of due process for it to be subjected to severe economic and technological infeasibility in being forced to comply. This is what they said to the Supreme Court of the US. However, Supreme Court of the United States said that if Congress intended that grounds of economic and technological infeasibility be foreign to the administrator's consideration of a state implementation plan, a court reviewing an approved plan cannot set it aside on such grounds. So what the court here did was to look at the law, and it looked at the law, and if the law states that there is no excuse for compliance, there is no excuse for economic reasons, there is no excuse for technological reasons, then that is the law and that must be complied with, right? So this is just the concept of technology forcing. So court here said that to allow petitioner's claim would permit a proposed plan to be struck down as infeasible before it is given a chance to work. But Congress clearly contemplated that some plans would be infeasible when proposed. So Congress has already considered these difficulties. And the fact that Congress did not put this down into law simply means that the intent of Congress was to have this implementation plan be followed strictly by government and by private parties, right? So it is all about legislative intent. This is Union Electric versus EPA. So now let's look at Section 37 as an illustration. Section 37 of the Solid Waste Act, because this is what is being implemented by the DENR and the Solid Waste Management Commission, as well as the DILG. Let's look at Section 37 and let us examine if there is an excuse for economic difficulties as well as financial difficulties. And if we examine Section 37, there doesn't seem to be any excuses at all. Okay? So now, if there is now a contest and it calls for the interpretation of Section 37, Section 37 is pretty clear that local government units must comply with the sanitary landfill requirement. And unless this is modified or amended by Congress, courts have no choice but to implement this provision of law. This is simply a tech forcing provision of laws. Maybe the technology is there, maybe the technology is hard to comply with, but let them try and comply. Force people to act, because that's the only way we can change people's behavior and we can change the course of our environmental degradation. So this is tech forcing Solid Waste Act. Okay, now let's look now at the rules of procedure for environmental cases. Okay, so the rules of procedure was enacted by the Supreme Court in 2010 pursuant to its rulemaking powers under the 1987 Constitution. And here are the guidelines for the rules. It evinces liberalized standing, right? It tells us that there must be an easy access to courts through citizen suits. Third, rules should implement the basic tenets of the precautionary principle. This is a basic foundation of the rules. And fourth, rules must provide other innovations like SLAP, other innovations like area-based management, other innovations like non-attainment areas. These concepts can also be applied to the pandemic problem that we are having right now. So all these rules, these are the guidelines that must be followed in the implementation of the rules of environmental procedure. Now, are there criticism of the rules? Okay, can courts, do courts really have the power to do this, to be an activist? So they say that the rules are indicative of judicial activism, such that it is not the duty of courts to enforce and implement the laws. Okay, and that the courts lack the skill and expertise. Why would you supplant the actions of the DENR when you are not even did not even study a scientific procedure. What you studied is the law and not science. So this is a criticism, and it makes judges policymakers. And the bad thing with judges being policymakers is that they are not supposed to be policymakers. They are not elected, and the rules are undemocratic. So this can be illustrated. This is a common criticism of the Dutch court ruling, such that when the Dutch court came up with a rule that Royal Dutch Shell must lower down its emission to 45%. Many said this is highly improper for the court to do. It is for the legislative branch to decide upon. It is for the people to decide upon in a referendum. But here, the took it upon itself to impose a requirement like that on Shell and probably with other companies. So it is undemocratic. It is of an elitist nature because judges are not elected, and this is not a democratic way of doing things. So, however, there's another story to the picture, and here are the advantages of the rules. Okay, rates ensure that environmental damage be contained or prevented in a speedy manner. What if the executive branch does not want to act? It behoves upon the court to come in to contain an environmental damage. Two, rates are an indictment of the executive branch's failure to enforce and implement the laws. Simply, we are allowing people to come in and enforce the laws because the Solicitor General, the government, has failed to do their jobs. And this problem is not only does not only appear here in the Philippines, but probably worldwide, because most citizen suit provisions, we can find them in laws in the United States. So it is a failure of the executive branch to act. Third, if you're going to force government, if you're going to threaten government officials with cases for violation of environmental laws under pain of contempt, okay, they will be forced to perform their functions properly. Okay, this has been the experience all along, and even some government officials even want to face a lawsuit of this nature because so that they can proceed against their own supporters, and they will be forced because they are under pain of contempt by the court. So advantages of rules. Okay, so obstacles to pollution control, they are institutional rather than technical. Expertise and skill are easily gained. The parties will file their own comment. They will present their own experts, and it is for the court to appreciate this evidence. So it's not really an excuse that the courts lack expertise because the parties will probably provide the expertise. Okay. And lastly, the most important thing is courts are enforcing the laws that were enacted by Congress. So there is much to support court intervention with respect to environmental protection. Now, let's look at the right to a balanced ecology. All right. Uh, right to a balanced ecology under our Constitution. It evinces a liberal approach to standing. It rejected strict interpretation of standing in civil procedure and torts because if you look at civil pro and torts, it will require an element of injury. You will have to show redressability and causation. And if we are going to require each and every people to have injury, then there's a great chance that their environmental rights will no longer be protected. Right to a balanced ecology is also enshrined in the landmark case of Oposa versus Factoran. Oposa versus Factoran is just a beautiful case, right? We have a right to a balanced ecology so that we can encourage people to easily file cases in courts so that they will not be hampered in the filing of cases. So injury in fact is no longer an insuperable barrier. In other cases, injury is required. In environmental law, it is relaxed. Okay? How good is the OPOSA doctrine? let me discuss to you how good OPOSA doctrine is. You Google OPOSA doctrine and you will see so many law review articles, so many law journal articles written worldwide. OPOSA doctrine has gained the praise of so many legal luminaries overseas. I, for one, I am a beneficiary because the moment you go to abroad and you tell them about Professor Tony Oposa, and the respect that they have for Tony Oposa is just great. Okay, so this is as good as it can be. We all know the doctrinal deficiencies of Oposa. You can see, you can look at the concurring, well, actually it was a dissenting opinion of Justice Feliciano in the Oposa case. But then again, this is our very own. This is our proclamation to the world regarding intergenerational responsibility. Why should we give up this case away? So we should maintain this case. This is a lovely case. It tells us about future generations. It tells us about intergenerational responsibility. We should be proud of Oposa doctrine instead of thinking of reversing the Oposa case. Now, let me discuss with you citizen suit because this is a problematic provision of the rules of procedure as well as in the Solid Waste Act and the Clean Air Act. Let's look at the rules of procedure provision on citizen suit. So it is section 5, and this is a narrow one because you are only allowed a citizen suit under the rules of procedure if you are representing others. The rules of procedure allows us to file a citizen suit only if we represent others, including minors or generations yet unborn. So this is of a limited application. But let's look at a better case of citizen suit, and we will look at the Clean Air Act. And this is the provision of the Clean Air Act. So it tells us that any person may file an appropriate civil criminal cases in a variety of cases. So this is one, the difference between the Clean Air Act and the rules of environmental procedure. Two, citizen suit provision has been severely criticized by Justice Antonin Scalia of the United States Supreme Court, the father of conservatism. He said that what Congress did was unconscionable, because what Congress did was to transfer the power of the executive branch to enforce and execute the laws. It transferred this power, or it shared this power to ordinary citizens, which should not be, right? Third, let's look at section 41. Why is it that they say that citizen suits do away with injury, that you need not demonstrate injury? Simply because if you look at the provision itself, the first paragraph, it does not tell you that there is need to demonstrate injury. It simply states there, any citizen may file an appropriate civil, criminal, or administrative action. It did not tell us that you must demonstrate injury. It did not say any injured citizen. Okay? So this is a grant of a procedural right by Congress for people to easily exercise their right on clean air. Right? Now, let us also look at Section 41. Section 41, citizen suits, it simply tells us that it is supplementary to government action. Okay? You can only exercise your right to citizen suit if government does not do their part first. That's why you need to send them a notice, a 30-day notice, that they must act. Otherwise, you will file a citizen suit. So let's look at the tense of letter A. It tells us any person who violates or fails. The tense is present tense. Why is this present tense? It simply means that the violation must be happening. It simply means that the violation must be occurring at the present time. It cannot be a past event because the character of a citizen suit, it is supplementary to government action. So if an event has concluded, if it's long past, this is not a citizen suit. It can fall under other provisions of the rules of environmental procedure. Okay, so it is present tense. So let's look at letter A. These are the Solicitor General actions, the Attorney General actions, wherein an ordinary citizen can take the place of a Solicitor General. If the Solicitor General does not want to file a case, then a citizen suit can come in. The next situation is are the certiorari actions with respect to illegal orders of government agencies, illegal or improper implementing rules of government agencies. And the third one will be the Mandamus suits, which simply tells us that if government does not do their functions, any citizen can force them to do so by virtue of a citizen suit calling for mandamus. All right. Let's look at here the 30-day notice, and it appears in letter C. Does the 30-day notice apply to the three instances? And the answer to that is, I think, yes, there was a problem with the typing here. It was inadvertently probably included in letter C because if you're going to really ponder upon the doctrine of citizen suit, it is supplementary in character and it should also apply in letter A and B. Anyway, under the implementing rules of the Clean Air Act, it applies to the three instances. Again, you need a 30-day notice to government agencies so that they may act upon the problem, and that's the only time that you can file a citizen suit. Okay, so Solid Waste Act has a similar provision. If we look at one case decided by the Supreme Court of the US, it states here that if Congress has accorded a procedural right to citizens, citizens can assert that right without meeting all the standard requirements for redressability and immediacy. So it does away with certain requirements of standing and injury. So I told you environmental law is just good because it allows people to easily access the courts and file cases in courts, right? So let me continue with the applicability of rules. Rules are applicable only to courts. Okay. In section 2, rule 1, the enumeration of laws in section 2 is merely illustrative so that future environmental laws should probably be covered by the provisions of the rules of environmental procedure. The important thing that we have to see here is that you must properly demonstrate that it is an environmental case for the rules to apply to you. There are so many advantages, the most important of which is the filing fees. Because if your case is not classified as an environmental case, there's a great chance that you will be required to pay huge filing fees, especially in cases of damages that person may file resulting from an environmental destruction, right? So this is section 2, rule 1. It is 9:35. I think it's time for us to have the game.
Yes. Thank you very much, Professor Galahad. For our participants, everyone who wish to join our quiz, we have prepared a Kahoot quiz. Let me share my screen. Okay. Yeah, can you see it? Yes. Everyone who wish to join are encouraged to use two devices to comfortably navigate through our quiz. Okay. The game pin is 872667. And after joining, please rename yourselves in the following format: your surname underscore the organization. Okay, we have five. Currently have five. Okay, so we currently have 13 participants. 14. Oh, okay. The quiz is designed by Professor Galahad, and we only have 10 seconds for each question. The quiz have a total of 5 questions. So after all of our participants join, maybe we can start. Okay, let's start. I think we need to finish the counter first before we can start. We have 9, 8, 7, 6, 5, 4, 3. We currently have 27 participants. 28. And 1. Okay, the quiz will now start. First question, what is the contribution of the Philippines to global emissions? Okay, we have A, 0.3%, B, 3%, C, 3.3, and D, 5%. We have 7 participants who got it right. Our leading participant is Kicks. Next. Under the GATT WTO, seals are protected because they are A, are endangered, B, are exhaustible natural resources, C, are national treasures of artistic. Okay. The game is too fast for me. And we still have Kicks. And third question, who among the following sang Colors of the Wind in the movie Pocahontas? A, Vanessa Williams, B, Lea Salonga, C, Celine Dion, and D, Judy Kuhn. Nobody got it right. And next. Which among the following is least regulated by the Clean Air Act? A, stationary sources, B, mobile sources, C, humans, D, fuel, additives, and substances. Okay, we have 12 participants who got it right. And we have Hadap from MLC taking the lead. And the last question, what is the nationality of Greta Thunberg? A, Germany, B, Switzerland, C, Norway, or D, Sweden? Okay, 12 got it right. So that's the end of our game, and our winners will be reaching out to you later on. We have Hadap um, got the the most number of. Ano. So I'll stop my sharing now. And thank you very much. We now, I give the floor now again to Professor Galahad.
Okay, I sure hope we are all awake. I usually ask these questions during my MCLE lectures among lawyers, and one question I also ask during those face-to-face sessions is the question is what is Euro 4, and what brings the entire audience down is a choice of an answer like Euro 4 is a team, football team in Norway. It is a car in the United States. It is a uh, dress in Europe. And the last that all the audience will like will be this choice. It is a hotel in Cubao, Quezon City, right? So these are nice icebreakers. Anyway, let me continue. And let's continue with applicability of the rules of environmental procedures. So we must note that under Section 2, Rule 1, rules are applicable only to courts in cases involving enforcement or violations of laws. So I told you it does not apply to fiscal's offices. It does not apply to other administrative agencies, only with respect to courts. Okay. Now, this is another problematic issue, not only with respect to rules of environmental procedure, but with respect to other rules, even under probably the 2019 revised rules of court. So you have here several prohibited pleadings, a motion to dismiss and everything. Okay. The rules tell us that it is prohibited. And yet, the problem is judges, they still entertain these prohibited pleadings, as most practitioners in this group would probably know. Okay? What is the remedy? The problem with judges who even entertain this is they even come up with a full-blown resolution of whatever is included in the motion to dismiss the complaint. And I think this is a problematic issue. Uh, what's the remedy? File an administrative case against the judge. Okay, I am suggesting that the rules be revised to include that just will just have the power to disregard this, and it will just stating in a decision that it is a mere scrap of paper with no redeeming value, because it already says here prohibited pleadings, and if they still entertain this, what's the use of the rules for? So we need to follow prohibited pleadings, and it needs to be properly implemented. Now, this is also another problem with the rules of environmental procedure, the prohibitions on TRO. Okay, here, except the Supreme Court, Section 10, no court can issue a TRO or writ of preliminary injunction against actions of government agencies. Okay, so it tells us that if certain government agencies are enforcing the law, okay, a lower court, an RTC, or the Court of Appeals cannot issue a TRO. You have to go to the Supreme Court to obtain that TRO, right? The problem is this is again very much violated by lower courts. Also, in a seminar sponsored by the DNR, I attended because I was invited by several lawyers who are also part of this group. I asked this question to their guest speaker, si former Justice Presbitero Velasco, and he too could not provide a clear answer. What's the remedy to this, right? Because lower courts still issue TROs. You see this happening in Boracay. You see this happening in Solid Waste Act cases. So, uh, is it only administrative remedy, or can we just say that can parties or can the government agency itself, okay, go ahead and ignore the TRO? So it tells us, rules tell us that a TRO may not be issued, but how do you implement such a rule? Okay, so can a government agency just ignore the rules? Now, this is the last issuance by the Supreme Court. I have not seen an interpretation by the Supreme Court yet of Section 10 of the Rules of Procedure. But part of the reason, okay, let's look at other laws prohibiting the issuance of a TRO. PD 1818 also does not allow the issuance of a TRO by a lower court, as well as Republic Act number 8975. 8975 does not also allow the issuance of a TRO, except the Supreme Court. Okay? Problem is, when these laws were interpreted by the Supreme Court said that a lower court may still issue a TRO when the case at issue or the issue in the case is of extreme urgency involving constitutional issues. So it takes it out of the prohibition if you allege constitutional issues in your case. In the case of WT Construction versus DPWH. Also, in Hernandez versus Napocor. Okay? Um, um, Napocor was putting up steel towers here, electric power lines, and people from Dasma did not like this, so they filed a case with the Makati RTC. Makati RTC issued a TRO, and Supreme Court sanctioned the issuance of the TRO by the Makati Court, saying that if the case involves questions of law, a lower court is authorized to issue a TRO. Okay. Also, in the case of Hernandez, it also stated that circulars of the Supreme Court never said or never stated that a TRO may not be issued by lower courts. All right. So this is the case of Hernandez versus Napocor. Uh, I have to tell you, these are past cases, and the latest issuance by the Supreme Court is still the rules of environmental procedure. Okay. And only the Supreme Court may issue the same. Okay, so unless there is a decided case by the Supreme Court interpreting the rules of procedure, I think the rules of procedure will take precedence over these past cases decided by the Supreme Court. That's only in environmental cases anyway. So Hernandez versus Napocor. Now, let's discuss contentious issues about SLAP. In past lectures, this has already been touched upon. Uh, in the rules of procedure for environmental cases, it tells us that the rules apply only with respect to courts. How about if you are facing a case before the fiscal's office? Because that's where they will file cyber complaints for cybercrime and other violations of law to inconvenience an environmental activist. Do you have a defense under the Clean Air Act if your issue is clean air, and also under the Solid Waste Act if your issue is solid waste? Okay, it states in the law that it shall be the duty of the investigating prosecutor or the court. So there is ground to say that uh, SLAP may be put in issue in cases before the prosecutor's office only if it involves clean air and solid waste, right? So this is a good thing for everybody. Actually, I have tried doing this when the rules were still in its infancy. I filed a motion for determination for SLAP with the prosecutor's office of Makati. The plan then with my client was to go all the way to the Supreme Court. But then the fiscal came up with a resolution on our motion, and the fiscal said that it's probably better to have a full-blown preliminary investigation with respect to the case. So we agreed, and in the end, the fiscal sustained us. But anyway, it can be brought as a defense before the fiscal's office, citing Clean Air Act and Solid Waste Act. In other cases, we must the rules of environmental procedure must still be followed. Okay, so there's ground to allege this defense in the fiscal's office. So Clean Air Act SLAP, it also applies to public officers who are just doing their jobs. Okay, and they will be swamped with cases before the ombudsman, before the fiscal's office. So this is a good a protection for people. This is a good innovation under environmental laws. Okay, now in one case, Supreme Court has already ruled SLAP does not apply in other cases. It does not apply in violence against women cases as stated in Mercado versus Lupeña. Okay? It would have been nice also if there was SLAP in graft cases so that people who are whistleblowers may be protected also and may not be subjected to harassment by the guilty parties. So this is SLAP. Now, the other thing that I'd like to discuss with the audience is the standard of damages in torts, because this is how we assess damages. This is how courts award damages. It is based on market and economic values. You will only get what you have lost, which is the difference between the commercial or market value of the property before or after the event causing the injury. If you have a car, it was hit by another car, your car suffered damages to the tune of 200,000, then you should only be awarded 200,000 and nothing more. That is based on economic efficiency, right? So the lower of uh, between the values of an injured resource. So this is the standard approach in torts and damages. However, let me tell you now a different approach with respect to environmental law and natural resources, because there's a whale of a difference in the awarding of damages in environmental cases. Okay, natural resource damages. This is enunciated in Section 16. This is a new one under the Clean Water Act. It states there that those who pollute the waters and the rivers are responsible to contain, remove, and clean up. So it's pretty simple and it's pretty straightforward. But let's look at clean up. What does clean up mean? And there's a standard definition for clean up in Section 3 of the Clean Water Act also. And this is the definition of clean up. It is not only removal. It also tells us restoration of the affected areas to their former physical, chemical, and biological state or condition. It is not replacement, but now it is restoration. And if you restore something, you restore a body of water, that will be very expensive. Okay? Let's say paying the fair market value of a car that has been totaled, the insurance will just pay you the market value of the car, and they will not just agree to you to have it restored because they might spend more. But in environmental cases, that is not so the case. The standard is restoration. So if the coral reefs are damaged, if one body of water is severely polluted by a polluter, then it behooves upon the government to ask the polluter to have the place restored. And restoration is very, very expensive because it requires a lot of experts, it requires a lot of activities and complicated procedures. Okay, so clean up operations. Now, what are the types of natural resource damages? It can be restoration costs, which simply means that you can acquire an equivalent resource to put it there in the area, it can be a replacement cost. So that if there are mangroves there, you can replant trees also. It can be based on use value. How much was lost by a private party or by the government? Let's say in the case of Boracay, it was closed down because of the polluting activities of several establishments there. Shouldn't they be also pay? What will be the basis for the payment? It is what the government expended for the cleanup of Boracay. Use values. Okay. It can also be non-use values. If a place is so sentimental to you, if a place is so romantic to you, courts have already ruled that this may be a basis for the valuation of a natural resource. So contingent valuation. So the question could be asked, how much are you willing to pay so that Manila Bay will not be reclaimed? And that can be a proper basis for the recovery of damages. You use elaborate questions to know from people how much they value something which concerns the environment, natural resource damages. Okay. Now let me talk about venue of Writ of Kalikasan and Mandamus, because this is very important to our practice. For most who are to those in the environmental practice and representing NGOs, let's look at venue of Writ of Kalikasan and Mandamus. Except for the writ of Mandamus, continuing Mandamus, you can file that with any of the three courts, RTC included, but with respect to writ of Kalikasan, Court of Appeals, and Supreme Court only. Now, this is very important. Why? I'm saying here, avoid filing with the Supreme Court. Why? Especially if you are not sure with your arguments, if you lack witnesses, because a loss in the Supreme Court sets precedent, it becomes part of the law of the land. And if we lose in the Supreme Court, it sets back the environmental movement by a century and by a mile. I'll give you an example. To those of you who have read the decision of the Supreme Court in the case of Senator Cynthia Villar with respect to her fight regarding the reclamation of La Papachea, you can probably notice in that case citations made by the Supreme Court in the case of Pahe versus Casino. That case has been very damaging for environmental law because the Supreme Court there stated that ECC is not a permit. It is merely a decision-making tool. Supreme Court said that Section 26 and 27, contrary to the Boracay ruling, does not apply because ECC is not in the nature of a permit. So if that is the case, okay, we should avoid filing with the Supreme Court. Let us always emphasize to our clients that the courts are not our savior, because the courts are also circumscribed by rules of evidence. And if we have no evidence, if our only evidence is Mr. Google or Siri, then it's not going to cut it. You look at the case of Senator Villar once more. The court said there that the study made by the um, uh, agency hired by Senator Villar is not really that convincing, because I think they did not really do a proper environmental study. Okay, so let's utilize the court when we think we have proper witnesses, when we are convinced with our arguments, then we file with the courts and we file with the Supreme Court. Otherwise, if we are not sure, let's not do it, because we are not only dooming our clients to losing in the Supreme Court, we are going to affect everybody else. Okay? Because as of now, you, me, and everybody else are bound by the decision in Pahe versus Casino. I am pretty sure some of us, some people in our group today, this morning, were involved in the litigation of Pahe versus Casino. So that's the situation at this time. Okay, so where to file? Uh, don't file with the Supreme Court. Now let's look at the history of the writs. Okay, These are constitutional and environmental rights. Okay? They were inspired by the writ of amparo. For those who belong to batch 91, 92 who took the bar exams, I'm pretty sure you will never forget that bar exam because that was the first time that the question, what is the writ of amparo, was asked. I do not know if anybody ever got that question because we did not have a writ of amparo then. So it is based on Spanish and Latin American jurisprudence affording special adjudication. So the story goes that in Mexico, one morning there was a person being chased down by the police, and there was also a person having coffee at a coffee shop, and the person who was arrested by the police shouted out the person having coffee, "Amparo, amparo," which literally means "help me, help me." And apparently, the person who was having coffee was a judge. And right there and then, the judge called up the arresting officers as well as the person they arrested, and right there in the coffee shop, held a hearing to determine the validity of the arrest of the person. So this is a speedy and quick procedure for the protection of certain rights, part of which is, among which is and are environmental rights. Okay, so special adjudication allows the plaintiff to go directly to a judge. Now, history of writs. Writ of continuing mandamus had its historical antecedents in the Taj Mahal case in India. Okay, this case was prosecuted by another great environmental lawyer, M.C. Mehta. And the Supreme Court of India here ordered government agencies to clean up, and it also ordered them to submit reports regarding the status of their cleanup, much the same as we did with MMDA versus no, residents of Cavite versus MMDA. History of rates. So let's look at some cases. Boracay Foundation versus Aklan. So Boracay Foundation, it simply tells us that you need not exhaust administrative remedies if you were not part of the EIA process anyway. So the process applies only to the applicant. Okay. Boracay Foundation also tells us that there is need to perform a full environmental impact analysis so that we will probably know the environmental impacts of a particular project. And the most important thing that we must consider with Boracay Foundation is it states there that prior consultation is required and that prior approval is required. If we look at the case of Pahe versus Casino, okay, let's just go over it. Pahe versus Casino, it tells us that we can utilize the rate of Kalikasan to question an ECC so long as we can show a causal link that the issuance of the ECC will bring about the dangers which rate of Kalikasan is trying to envision and avoid. Okay, so you must say that the ECC will contribute to environmental destruction. In the case of Senator Villar, court said that there was a failure to demonstrate that the issuance of an ACC will lead to the dangers envisioned under the writs. Okay, Pahe versus Casino, it also tells us that the statement of accountability must be signed by the project proponent so as to bind the project proponent to the conditions of the ECC. Okay? And this is the saddest part of the decision in Pahe versus Casino. It tells us that Section 27 in relation to Section 26 is not a requirement for the implementation of projects because the ECC is not a permit, it is only a decision-making tool. We can always hark back to the decision in Boracay Foundation. By the way, I do not know why the Supreme Court is not mentioning Boracay Foundation. They are not saying that they are overruling Boracay Foundation when they quote Pahe versus Casino. Even in Pahe versus Casino, there is no citation of Boracay Foundation. So, Boracay this Pahe versus Casino is a black eye to the environmental movements. I don't know how long and how far we are going to wait before we can probably reverse Pahe versus Casino. But this is a word of advice to many. Okay, if we file a case, okay, especially environmental cases, let us prosecute it to the end. Let us prosecute it to the best of our abilities. Because in Pahe versus Casino, we cannot totally blame the Supreme Court for coming up with that decision. Because if you read the decision in Pahe versus Casino, the group of Representative Teddy Casino did not file, let me repeat, did not file a comment. That's why the Supreme Court was left to listen to the other parties in the case. Also, DENR was also of the idea that ECC is not a permit, it is only a mere decision-making tool. So we learn our lessons from Pahe versus Casino, and let us pray that in the near future, we can have this case reversed. Okay, so this is Pahe versus Casino. Court there said that ECC is not a permit. However, I'm telling you once more, there was a failure to probably cite the Solid Waste Act, because it is clear under the Solid Waste Act that when Congress talks about an ECC, they mean a permit. And a permit, an ECC is supposed to be. Because if you're going to look at Section 38, okay, Section 38, the heading is Permit for Solid Waste Management Facility Construction and Expansion. So the term permit here simply refers to the ECC. So in the future, when we will have an opportunity to argue and fight a case with the Supreme Court, we can probably cite Section 38 of the Solid Waste Act that talks about an ECC in the nature of a permit for management facility construction. I don't have that much time, so let me just jump to the last part of my lecture. Anyway, all these matters are in the rules, and they have been touched upon in previous lectures. Now, I'd like to make a closing statement, and I will try to cite a case decided by the United States Supreme Court, and this is the importance of the rule of law. In the case that I cited, the Tennessee Valley Authority versus Hill, the case involved a newly constructed multi-million-dollar dam, I think based in Tennessee. Okay? And when this was newly constructed, it was ready for operation. One person went out fishing along the waters of the dam. And that person was able to catch a seemingly harmless creature. And this creature, upon proper examination, okay, was revealed to be a snail darter. A snail darter, by the way, is included in the Endangered Species Act of the United States. And that law provided that if there is an endangered species, you cannot operate a project that's going to harm them. So this case went all the way up to the Supreme Court. And the Supreme Court, when it tried to decide, they were bothered by the equities of the case. Why should we close down a multi-million-dollar dam in favor of a small, harmless snail darter? Okay? Eventually, the Supreme Court in this case said, our function is to implement the law. It is not to follow the equities or any other reason not provided by Congress. If Congress thinks otherwise, or if people think otherwise, their remedy is not with the Supreme Court. Our duty is to faithfully enforce the laws. And the law has spoken, and that dam cannot be operated. When it decided the case, the Supreme Court cited a passage, cited Sir Thomas More, in A Man for All Seasons. And let me read that passage for the benefit of everybody. So Sir Thomas More here was having an argument with Roper, his son-in-law. So Sir Thomas More said, the law, Roper, the law. I know what's legal, not what's right, and I'll stick to what's legal. I'm not God. The currents and eddies of right and wrong, which you find such plain sailing, I can't navigate. I'm no voyager, but in the thickets of the law, oh, there I'm a forester. What would you do? Cut a great road through the law to get after the devil? And when the last law was down, and the devil turned round on you, where would you hide, Roper? The laws all being flat. This country's planted thick with laws from coast to coast. Man's laws, not God's. And if you cut them down and you're just the man to do it, do you really think you could stand upright in the winds that would blow then? Yes, I give the devil the benefit of law for my own safety's sake. So, ladies and gentlemen, let's all give the devil the benefit of law. Let's all give our enemies the benefit of law. For when our enemies turn down on us, the only protection we will ever have will be the law itself. Thank you and good morning.
Thank you very much, Professor Galahad, for that very substantive lecture on active participation of the government in environmental protection and its duties to implement its mandates, especially the courts and its observance of the rules of procedure for environmental procedures. Now, for the awarding of certificates, the Legal Education Board wishes to award this virtual certificate of appreciation to Professor Galahad Pebedi. Environmental law advocate and professor of Far Eastern University, for sharing his time, knowledge, and expertise as resource speaker during the Environmental Law Teachers Online Training Program 7 session, Role of Courts in Addressing Environmental Protection in the Philippines, held by a Zoom virtual conference, given this 10th day of November in the year of our Lord 2021. Signed on behalf of the board by Chairperson Ana Marie Melanie B. Trinidad. Again, our warmest thanks to you, Professor Galahad. Before we move on to our next topic for this session, let us have a 5-minute wellness break. And we'll be back by 10:18. Thank you very much. So, as we move on to our next part of the session, to introduce our next resource speaker, we have with us today the Climate Law and Policy Specialist of Asian Development Bank, Ms. Briony Eels. Briony works with the ADB's award-winning Law and Policy Reform Program. She has dedicated 2 years to researching climate change litigation, law and policy in Asia and the Pacific. She is writing on working papers on climate change litigation, law and policy-based research. Apart from being an absorbing read, the papers will also support practitioners working on climate and sustainable development law in Asia and the Pacific. Briony understands the legal challenges of large-scale infrastructure development as she spent 4.5 years working on a multi-billion-dollar mining development project. Ladies and gentlemen, let us all welcome Ms. Briony Eels.
Thank you so much, Gab. Hi, good morning, everyone. It's such a pleasure to be here. Thank you to the Philippine Legal Education Board for inviting me to this lecture series. Okay, so climate litigation and climate law. When I started in this field, there was a big debate about, is climate law and climate litigation a separate body of law, or is it just a subcomponent of environmental law? And there are theories either way. But I think what I want you to take away from today's discussion with me is that climate litigation will touch all aspects of practice, because climate change will touch all aspects of life in the 21st century. And what I think it takes is consciousness and awareness about what is climate change, what are the sources of the emissions, how does it affect our lives? And when you understand that, then you will start to see if there's a climate dimension in the case that you are running. Next slide, please, Angelo. So that's why for my structure today, I will touch very briefly on the climate basics before getting into climate litigation. Next slide, please, Angelo. And I think we can go to the next one, please. Okay, so you're all aware that the COP26 is happening now for the Paris Agreement. And last month, the United Nations Environment Programme released this updated emissions gap report. And essentially what it does is it tracks the difference between where do we need to be with the emissions reductions to meet this goal under the Paris Agreement of limiting climate change to 2 degrees, making best efforts to limiting global warming to 1.5 degrees above pre-industrial levels. And where are our pledges currently at? So you can see on this graph, the 1.5, 1.8, 2 degrees range, and then you can see sitting way above that where the current policies are. So we have a 66% chance of a 2.8 degree warming if on the current policies. That's 2.7 if countries around the world meet their unconditional pledges under the nationally determined contributions. Now, 2 degrees is, and then unconditional pledges are 2.2 degrees. Now, let's bear in mind what's at stake. For the Philippines, 99% of the world's coral will die if we reach a 2 degrees level of warming. But if we can limit warming to 1.5, then we might just save 10 to 30% of the world's coral, and the Philippines is in the heart of the coral triangle. Next slide, please, Angelo. So looking at the greenhouse gas emissions for the Philippines, like I said, it's worthwhile orienting yourself about what climate change means domestically when you're running litigation. So in the Philippines, this is what the graph looks like for current emissions. And you can see over to the right, there's a BAU, which stands for business as usual. And then underneath that, that's what the conditional pledges will take us in 2025 with the level of emissions. And then you can see that if the Philippines is able to meet its conditional targets, then there will be a sharp drop off in emissions. And that will be within the fair share range. So on the far right of the graph, you can see a 2030 fair share target. And that's what that means. That's where the reductions need to be if everyone is to do their part and to limit global warming to 1.5 degrees. This graph also shows us that the Philippines' largest emissions source is the energy sector. Now that's because 70% of the Philippine energy mix is still coming from fossil fuels. So if as a lawyer or your students are thinking about how do we make a difference, where should we be litigating from a climate change perspective, always come back to what are the sources of emissions so that you can understand what litigation might actually make a difference. Moving to the next slide. So let's look at climate litigation. Thanks, Angelo. So as it was mentioned, I just spent over 4 years working on a series of reports on climate law, policy, and litigation. So it's 4 reports, as you can see there. It's available to download for free from the ADB website. The first report, the yellow report, looks at climate science basics so that you can get a grasp of where the useful sources of information are. The second report, the blue report, looks at climate litigation. It is looking specifically at climate litigation in Asia and the Pacific and beyond. And it's one of the most comprehensive volumes of information about different types of litigation. Next slide, please, Angelo. Now, in writing this report, we didn't focus on different countries and the different litigation in different countries. What we did is we broke the discussion down into trends. What are we seeing globally and in Asia and the Pacific with climate litigation? And the most popular form of litigation still are these big strategic cases against governments to hold them accountable for their climate action or inaction, followed very closely by permitting and judicial review. A third area is cases against private parties. So these are lawsuits against corporations, which are really starting to pick up globally, less so in Asia and the Pacific. And then we devoted a whole section on adaptation litigation. And that's because Asia and the Pacific will see some of the first and worst impacts of climate change. And if we ask, well, what adaptation means, it is we must learn to live with climate change. We can't stop it, no matter what we do. So we need to make our societies more resilient. So what's the litigation? What does that look like, this adaptation litigation? And then there is litigation involving people who are vulnerable to climate change. Moving to the next slide. Okay, so in this holding governments accountable, this big facet of strategic lawsuits, what we find, the legal rights that are being used are usually human or fundamental rights, constitutional rights, which is by far the most popular kind of legal right to use in Asia and the Pacific, statutory or legal rights, which are less popular, and some new and emerging litigation, which is based on the Paris Agreement. So what are the obligations of countries now that they have signed the Paris Agreement? Next slide, please. And in this holding governments accountable, you have some of the most famous litigation globally. So you would have heard of the case of Agenda, the Agenda Foundation, that sued the government of the Netherlands, saying that it had a duty of care to protect citizens from dangerous climate change. And the lawsuit relied on not constitutional rights, but rights that are embedded in the European Convention on Human Rights. And the court agreed that it had an obligation to hold the government accountable for these rights on the grounds that under the Constitution, it had to protect people's right to life and their right to a family life, and then that was linked to these convention rights. So the order in the Agenda case, which was upheld by the Supreme Court, was that the government must reduce its emissions by at least 25% by 2020 relative to 1990 levels. Now, the court actually did consider this issue of separation of powers. Professor Galahad mentioned this before, that there was commentary to say that this was a dangerous decision. Was the court interfering with the separation of powers? And the court said, well, we still have an obligation to ensure that the government complies with the law, that it complies with constitutional rights. And it has also signed the Paris Agreement, and we have the IPCC reports, which tell us that climate change will affect society, and it will be dangerous, and it will affect and undermine the right to life. So in setting the emission target, it didn't tell the government how it should meet that target, what the policy should be, merely that it should set that target. So that's the distinction it drew between saying we can make this decision and we're drawing the line here, we're not getting involved in policy. And there are other decisions. So I've mentioned these from Asia, Advocate Padam Shrestha against the government in Nepal, where this was a constitutional rights-based case. And in this case, the plaintiffs, or the petitioners rather, asked the court to issue an order directing the government to pass a climate change law, and the government and the court agreed, because it said climate change is an existential threat. It is undermining constitutional rights. Therefore, and it also has a climate change policy. It can't implement a climate change policy without the law. Therefore, it must pass a law. I won't go into the Neubauer case from Germany. I have put the bushfire survivors case in there as the last case on the slide. This is a case from Australia, and it's an interesting case because it shows a different perspective for how you can bring this type of legislation. And it's a case run against the New South Wales Environmental Protection Authority. And it said you have a statutory duty in the policy to actually put more than aspirational statements. So it can't just say, oh, we're planning to do something about climate change. It said that the policy must have teeth. So please look to this case as an example of a different way of running this climate litigation. Okay, let's move to judicial permitting and review. This is also a very popular source of climate litigation. And these cases typically focus on emissions. So targeting coal-fired power projects, coal mining, leave it in the ground, transportation projects, and land use and forests. And they would argue that the ECC, or the Environmental Impact Assessment, hasn't adequately taken climate change into account. Next slide, please. I've given two cases. I actually only have 20 minutes to talk to you and only have 8 minutes left. So I won't go into these cases other than to say that, these are examples of how you can run this litigation. And I've given another Australian case because it looks at a duty of care. So it's the duty of a minister to take into account climate change when they're making a decision about an environmental impact assessment. Next slide, please. This third area is litigation against private parties, and it is a growing area of litigation. So in the Philippines, you've seen a big case against the carbon majors in the Philippine Human Rights Commission. But in other areas of law, we're starting to see litigation against companies to say that they have a duty of care to reduce their emissions. And that's an example from the Netherlands again. And there are also other duties from Indonesia, for example, about wrongful damage to forests. So next slide, please. I'm about to get a visitor from my son, please excuse me. Okay, so looking at this first case, I'll go to the Royal Dutch Shell case because it is such an important case happening right now. And this is a case run in the Netherlands using agenda-style arguments, but instead of running them against a country, they're run against a company. And that is to say, again, under the Dutch civil law, the civil code, there is a duty of care to ensure that the company does not release emissions and cause dangerous climate change. And that duty of care, it was argued in this case, was informed by the constitutional rights to life. And the court found that there was an unwritten standard of care laid down in the Dutch Civil Code, meaning that Royal Dutch Shell had an obligation to reduce its emissions by 45% from 2030 relative to 2019. And it's a broad decision. It says there's an obligation to reduce emissions in the company itself, but also in the consumers that use its products. And we will expect to see litigation like this picking up and moving around the world. As I said, there's a third decision there that I've referenced, which is an Indonesian case. And it's a case about deforestation and forest fires. This is really topical for the Philippines, given the amount of deforestation and the amount of litigation that occurs, particularly in regional trial courts around illegal logging. So it's worthwhile looking at this case. We cover it in our climate law reports. Next slide, please, Angelo. As I mentioned, there is another category of adaptation litigation. So these cases are a bit like the large emission cases. They tend to be against governments. They're often based on a constitutional right to life, and they might argue that the government has an obligation to create suitable plans for adaptation. Or they might look at, in an environmental impact assessment, the obligation of the project component to consider not only how the project will impact climate change, but how climate change will impact the actual project itself and whether it is resilient enough to withstand the impacts of climate change throughout the life of the project. Next slide, please, Angelo. And I'd like to go, keep going to Philippine litigation, which will be here. Thank you, because I have only a few minutes left. Okay, so I wanted to quickly touch on 6 cases that have been run in the Philippines, and we treat them in our report series as climate litigation, even if these cases may not explicitly reference climate change in them. And we do that because it's this notion of climate consciousness. So in these cases of Opposer and Factorin, this is clearly a climate change case. And why is that? Because Tony Opposer clearly argued that if you clear forests, you clear carbon sinks and you reduce the Earth's capacity to draw down greenhouse gases. So that's a very clear early climate case from the Philippines. When I started the project, I expected to see a lot more litigation in the Philippines around climate change. I mean, there's such excellent environmental litigation here. But you can see I've put a tick and a cross showing where cases have been successful. And Professor Galahad talked about the Paje and Caseño case and why it was unsuccessful, which was largely for evidentiary issues. But the one thing I wanted to say in that case is I read the decision. It's a case about a coal-fired power plant in Subic, but rarely in the decision does the court talk about climate change. So in 2015, we need to be thinking about it's a coal-fired power plant. That's a climate change issue. Next slide, please. It should be, sorry. That one there, about resident marine mammals, Rest Town Condominium and Segovia. So I understand the marine mammals case has been covered in previous discussion. So I'll move to the Segovia case, which is the most recent case beyond the carbon majors case about climate change. And it is specifically a climate change case where it's about a writ of Kalikasan and seeking orders for a continuing mandamus to create road sharing in the Philippines based on a principle of road sharing. And I also like the second orders that were sought, which were to compel the president and members of cabinet to start using public transport, which is a very creative remedy, but ultimately too creative for the court. But I think what is really important to comment on in this case is that the court felt that the petitioners had failed to show that the government was guilty of violating or neglecting environmental laws, or that such acts violated constitutional rights. And in making that finding, the court was actually still aware that the government was not meeting its own standards on particulate levels and with air pollution. And it kind of reached a conclusion that said, well, the government is reducing particulates. It's not meeting those standards, but it's still trying. And I think that's something that is a challenge in the Philippines. I think talking the court through why near enough is not good enough will be really critical in a climate context, and also explaining how that has implications for future generations. And just quickly on this issue of future generations, I know that in the Segovia case, the court commented on not locking future generations in the dangers of orders that bind future generations. And I know that the Supreme Court has looked at whether it should reopen the principles set out in Opposer versus Factorin. But the same argument applies in climate change. I understand that the court is very clearly concerned that, unborn generations can't be in court. They can't represent themselves. So why should they be bound by any remedies that the court passes on their behalf? But the same arguments apply in the climate context. We are locking future generations into the implications of climate change. By failing to act now, we are making the remedies for climate change even harder for future generations. And this is something that the New Bauer case looked at in Germany and said it's unacceptable to make future generations work so hard and to deprive their liberties so greatly. So next slide, please, Angelo. Just quickly, there are some resources. So in our report series, we have one report about national legal frameworks. And then the next report is on international legal frameworks. Next slide, please, Angelo. That's the international legal frameworks. Next slide, please, Angelo. So I think to sum up, climate litigation will use the existing tools and remedies that you have available to you. And in the 21st century, legal practice will be touched by climate change. But what we need is conscious lawyering at every level. Be aware of how climate change is impacting the world around you and how it is impacting your practice. It is a new area of law. It will require creative thought around the arguments that you can run. The Supreme Court of the Philippines is very concerned about when it issues an extraordinary remedy and how it does that, and that it shouldn't be interfering in public policy setting. But there are examples from all around the world and from Asia about how lawyers have addressed this issue, have argued this issue, and how courts have grappled with this issue. So do look for examples, comparative examples. Do not just go to the US, go to Europe, go to other parts of Asia, and there are examples provided in our reports. And I think what's really needed is skill to walk the courts through the impacts, the applicable principles, the comparative litigation, so that we can start coming up with climate responsive remedies. Thank you so much for your time, and apologies for going over by a few minutes. Thank you.
Thank you also to Brioni for that very insightful lecture on climate litigation, raising the impacts of obligations and issues of holding governments accountable, cases against private parties, adaptation, and Philippine climate cases. Thank you also for the resources that you have shared to all of us. Now for the awarding of certificates, the Legal Education Board awards this virtual certificate of appreciation to Brioni Eels, Climate Law and Policy Specialist of Asian Development Bank, for sharing her time, knowledge, and expertise as resource speaker during the Environmental Law Teachers Online Training Program, 7th session, Role of Courts in Addressing Environmental Protection in the Philippines, held by a Zoom virtual conference. Given this 10th day of November in the year of our Lord 2021. Signed on behalf of the board by Chairperson Ana Marie Melanie B. Trinidad. Thank you very much again. We now move forward to our moderated open forum. To our participants, if you have questions, you may click the raise hand button in the reaction function located at the bottom and right side of your screen. You may also send your questions in the chat box and we will just read it for you. We have with us Matthew from ADB, who will be our moderator. Matthew, the virtual floor is yours.
Thank you very much indeed, Gab, and thank you both Professor Galahad Benito and Brioni Eels for your great presentations. I mean, we've had another rich session, but I did think the exciting thing, and just commenting on Brioni's presentation, I was listening to another climate litigation presentation yesterday delivered by Matt Floro from the New South Wales from the Environmental Defenders Office of Australia, talking about climate litigation, a number of generations. He mentioned 3 cases that I was actually the counsel for, which were very early climate litigation cases in Australia from 2006 and 2007. And it also struck me how there has been, over the last few years, a great change in the way that courts are addressing climate litigation, whether it's because of the number of cases being brought, whether it's also because of the teaching of students, the inspiration to commence cases, and also the work done over the years, bringing together environmental law principles and applying them to climate litigation cases. But I do think the interesting thing that Bryony has mentioned is this idea that climate litigation can touch all sorts of cases. And I know you only had 20 minutes, Bryony, but there was a lot of other corporate litigation that is possible to mention in the context of climate change. Perhaps you could just give us a couple of minutes talking about some of those particular cases, because they might also be relevant in terms of once the Philippine Human Rights Commission comes out with its final report on the climate, the carbon majors, where that may lead to in terms of shareholder action, in terms of corporate governance and corporate regulation, which is very much emerging as a new area in climate litigation. I don't think it'll replace traditional issues, but it's certainly a new area. So maybe you could make a few minutes comment on that. And then I think Dean Daniel Diaz has a question as well that I'll call on Dean Diaz.
Yeah, thank you. I'm unmuted. Thank you, Matthew. Yes, this is really a growing area, and really what some of this litigation is targeting and are things like director duties and obligations to disclose climate risk. And this is becoming very topical because various regions around the world are starting to regulate around ESG principles, so environmental and social governance principles, and what the duties are for companies to disclose their level of climate risk. So some of the interesting litigation is again coming out of Australia, which is very exciting, being an Australian, having watched climate litigation be very quiet for a number of years. So parties suing banks or superannuation funds for failing to disclose their investments in fossil fuel-based projects and the risk that entails across their whole portfolio. And so these are shareholder actions saying, the board of directors has this obligation to disclose. As I mentioned, there are also going to be more jurisdictions around the world that impose this requirement of reporting on directors. So once this is in place, that's another legal avenue for parties to sue companies. And it means that in the Philippine context, you're not looking at relying on the environmental rules of procedure. You're looking at a corporation's action about director duties. And so it's a different class of action, but it also means that you're getting away from arguments about how does climate change impact future generations, which the Supreme Court seems quite skittish around here. Another big case that has just been filed in Australia is a case against Santos, which is a very big gas giant. And now Santos is a member of the Climate 100 Plus initiative. And that's a global initiative that many companies are signing up for. And they're saying, we've got these targets and we're going to be carbon neutral. I think it commits to being carbon neutral by 2040. But what I think it's the Environmental Defenders Office has done is it's actually taken Santos's promises and actually done the sums and said, no, you actually won't be. Like on your own reporting, you will not be carbon neutral by 2040. So it's suing Santos on the basis of greenwashing, which is this claim that you're fraudulently claiming to be green when you're not really green. So again, this has got nothing to do, this is not an environmental lawsuit. This is a matter under consumer law, corporations law. It's about what companies are declaring. So thank you so much for picking up on that, because I think it's a very big area. It's very big in the EU, in London, and I think it's an area that could be very ripe for litigation in the Philippines, along with this idea of duties that you've seen in the Netherlands. Again, the Philippines has a law of negligence. So you could be saying to some of the big emitters here, actually, you have this unwritten duty of care that's informed by the constitutional principles, which are the right to life and the direction that the government has to ensure that, you know, there's a clean and healthful ecology. So it's merging those different types of principles together.
Thanks, Brownie. And so Dean Daniel, I think I saw your camera was on. If you could turn on your microphone and please ask your question. Thank you. Sorry,
sound.
The sound is not coming through. I'm not sure why the sound is coming.
Hello.
Yes.
Yes.
Okay.
Thank you very much.
Thank you. Now, again, thank you. And it was wonderful to listen to the lectures of Professor Galahad and Professor Brioni. And as an instructor teaching environmental law, I have actually questions after listening to the lectures, as I have said, because I believe everybody in the training agrees that this area of law, environmental law, especially the rules of procedure for environmental cases and the rules of court, the rules of court in environmental litigation, which of course discussed to us by Professor Galahad, is a very wide area, a very rich area. But as I have observed, curriculum of most law schools actually do not give so much avenue for this subject matter to be discussed or imparted to the students. And as a matter of fact, I looked into different curriculums. I think other law schools only have natural resources and environmental law. There's only one subject for the entire study of the JD program or Bachelor of Laws, and that's the Natural Resources and Environmental Law. Now, with the rules of procedure for environmental cases, that particular subject is actually incorporated, some incorporated to special proceedings, some incorporated to natural resources and environmental law again. But there is really no specific subject that is allocated for this subject matter. So I would like to ask to Professor Galahad or to our other resource speaker about their suggestion on how to really give focus onto this, because I see the importance and it's being very essential how law schools should impart this particular subject matter to our students. Are we ready? I mean, with the the weaknesses also, as I've seen it earlier in the discussion or in the lecture, the weaknesses of the rules of procedure for environmental cases. Are we ready to have this as one of the core courses in the JD program? That is my question, and I would like to ask it to Professor Galahad first.
Yes, thank you for the question. Yeah, my experience is this. If it's a 3-unit course summer session, I can probably lecture on the rules of procedure in 4.5 hours, covering only the civil part and the special civil action, excluding the rules on evidence and the criminal aspect of the procedure. So it is really tremendously hard to incorporate rules of procedure. And you also have to consider that students, they study rules of civil procedure, criminal procedure, and that's probably around 7 to 9 units. And we are trying to teach them the same concepts in only a 2-unit course. It's almost impossible in a 2-unit course. But what I do is really to force myself just to lecture on the civil part and the special civil action, because it is just an important part of environmental law. So I think almost all professors will agree that we should devote for a 2-unit course at least 4 hours, which is already a big chunk of our load. And for 3-unit courses, that should be 4.5 to 5 hours. We will have to force it and sacrifice other topics, take it out, because this is one big thing. Unless the law school has an elective course dedicated to procedure, I don't think even if you incorporate this in other subjects, the professor might not be in a position to teach it, because this is environmental law and they're teaching another form of law. So I think the proper way to do this is to really incorporate this in a 2-unit course. It's tremendously difficult to incorporate this in a 2-unit course, probably in a 3-unit course.
Thank you very much.
Okay, thank you.
Yes.
Thank you, sir.
We have a question from Jelly Molino. Would you like to ask your question, please?
Okay. Good morning. So my question is for Professor Bioni. I haven't read all the reports of ADB, so I am interested to know if in your review of potential litigation cases involving climate change, was there a specific case involving administrative law on contract award? Just to give you a background, in 2019, I work as consultant in one of the projects of the Philippines for the award of a construction of a dam that is funded by official development assistance. And the requirement is that there is a tied to aid, meaning that the contract itself already mentioned the construction company that will do the construction. But when I reviewed the proceedings, there was no environmental impact assessment yet. There was no social impact assessment yet before the award of the project. So I actually recommend that the potential use of environmental litigation to stop the award of the project till after all of those due diligence were made. Because how can you make the clause on the contraction clause that they will comply with all of these environmental recommendations if I am the contractor and I haven't read? So there's no meeting of the mind yet. So I could always say that, yes, I said that, but I didn't know what will be the recommendation of the assessment. So I am interested, like, can we push, because my recommendation is really bring a writ of Kalikasan case to stop the award of the project till after that particular due diligence have been complied, so that the contractor knows the extent of its responsibility.
Yes, we do. So we have a whole section on judicial review and environmental permitting, and that looks at these kinds of cases. So, for example, there was a case objecting to the construction of an airport in Goa in India, and it looked at difficulties with the environmental impact assessment, and the court ordered that that the government had to go back and do another review of the environmental impact assessment before the project could proceed. There's another, so we do have a whole section. There's another really interesting new case from Papua New Guinea. I will put the name of it in the chat, looking at a similar issue about what the requirement is for consultation with community members. This is something, it's very hard to find in many cases about what do participatory rights look like. And so this particular case, it's an early case. It's there is yet to be a full judicial review, but it's saying things like there must be meaningful participation with community members. The EIA must be disclosed in a way that community members understand. They must have the opportunity to comment on the EIA. We must see that the government and the project proponent is taking that into account because local knowledge is relevant. So yes, we do cover in administrative law in the report series, and it's worth taking a look at that.
Thank you.
Thank you.
I do know that we've sort of run out of time, and I do wish to thank Professor Galahad and Bryony for the wonderful contributions that they've made. We also do have their presentations because, again, there's a lot of material, and I've seen a couple of questions. Thank you, Professor Galahad, for answering that in the chat box. The important thing for us, from the teaching perspective, is just that depth, and I think Professor Galahad has highlighted this. Within the limited amount of time we have to teach our environmental law courses, what do we focus on? How do we effectively communicate, in a 2-unit course over 1 semester, this amazing corpus of environmental law that we know has changed not only in the Philippines, but in the region. And this is really quite a challenge. The ADB has launched just recently at the Regional Task Force to look at sort of a fundamentals of environmental law course, a curriculum within the Mekong countries, but with links to colleagues in the Philippines on trying to identify some of the material. But it's also clear that one course within a JD or an LLB is clearly not sufficient for some of these things. So that's also why some universities have developed Masters of Environmental Law programs. It's something that Professor Kong Falak in Cambodia is very keen. He started a Masters of Human Rights Law in Panasatra University in Cambodia. And this is also something that we would like to think from. Moving from the single course in the JD, is this something that should be offered for master's courses, and how that can be done and how resources can be pooled together. One thing that's often done, certainly in my familiarity in Australia, is that universities often come together to allow students to do a number of different courses in different universities, so that if one university is teaching climate litigation and another one is focusing on renewable energy or pollution law or environmental governance or ESG, then that student can bring together a number of subjects to develop a master's course. Is that something that we could look at in the future? So the idea of, lectures like this and the topics that we've seen show that there is a vast depth to each of these topics. How we teach them within the hours that we have allocated is clearly going to be a significant challenge. On that note, I would like to thank Professor Galahad for his presentation and Bryony for her presentation. We appreciate all the questions, and I'll now hand back to Gab. Thank you very much indeed.
All right. I suppose that ends our very enriching open forum. Thank you, Matthew, Professor Galahad, and Bryony. Also, thanks to Dean Diaz, Attorney Jelly, and to all our participants. Before we end today's session, we would like to congratulate you, our participant, for your continued support in the training program. As we near the end of this training, we would like to announce that for the remaining sessions of our topics and invited resource speakers are: for the 8th session, we will be having the panel discussion on climate change law with DENR Undersecretary Annalisa Te, Attorney Antonio Lavinia, and Commissioner Rachel Ann Herrera. For the 9th session, we will be having how to design an environmental law clinic, experiences and challenges, with Dr. Georgina Lloyd from UNEP and Attorney Donna Gasgonia and client Earth Joyce Melcartan. And for the 10th session, our topic is Environmental Law in Asia, Environmental Law Academics panel from Southeast Asia, and Opportunities for Comparative Law, with our resource speakers from India, Dr. Nupur Chowdhury, from Sri Lanka, Dr. Carmina Gunaretta, from Myanmar, Dr. Jonathan Lejublad, and from Malaysia, Dr. Hanim Kamarudin and From the Philippines, Attorney Antonio Oposa Jr. And for our non-mandatory session, our 11th session, the topic is environmental law in the Anthropocene. With our resource speakers, Attorney Riza Linda Jimeno, Attorney Antonio Oposa Jr., Attorney Lorna Kapunan, and Attorney Gala Halve. The certificates of completion of the training will be given to the participants who have attended 8 out of the 11 sessions. Lastly, we invite everyone to join us for an interview and share your comments, insights, and experiences in our training program. The links for the interview form is sent in our chat box. You may fill it out to schedule an interview with us and and can we also have a photo session? May we ask everyone to join us by opening your video cameras? And then we'll have Angelo to take our pictures. We currently have 78 participants, so we would like to see your lovely faces. Okay, take it away, Angelo.
All right, everyone. On 3, 1, 2, and 3. Right. Hold on. I will just move to the next. All right. 1, 2, and 3. All right, I have everybody.
Okay, thank you very much, Angelo. And as a last reminder for our participants, please don't forget the registration form for your attendance and the evaluation form. We hope everyone enjoyed today's session and see you onto our next session in November 17th. Thank you very much and goodbye, everyone.